Good evening, everyone. Welcome to our webinar, Nigeria Data Protection Regulation, NDPR. I am Suhail Fakhruddin, the Business Support Manager of Shelt. We have with us here our CEO, Mr. Yusuf Abillama, and our Business Development Manager for Nigeria, Mr. Walid Bouabsi, whom would like to greet you.
Hello, everybody. We are very honored to have Dr. Ayo with us and all the team of Shelt. And so I hope that everybody will benefit from this webinar. Thank you all for attending. Thank you.
Good afternoon, everyone. Glad to host you once again in our webinars and looking forward after the interstate travel opens to see you and meet you again in Abuja as well. And hope to take our discussions further to the next level soon. Good luck.
With the exceptional rise of digitization, the unauthorized use of personal data by service providers is exposing the interests of individuals to grave challenges and risks. In this webinar, Shelt is honored by hosting subject matter expert, Dr. Ayodele Bakare, to present the Nigeria Data Protection Regulation, NDPR, principles and compliance requirements, in addition to NDPR implementation and enforcement framework. Please join me as well welcoming our guest speaker, Dr. Bakare, the head of network unit at NITA. Dr. Bakare has over 17 years of experience in private and public organizations in the areas of networking and system architecture, application management, IT governance, information security, and cloud computing. He is a certified PECP ISMS Senior Lead Auditor and a member of the Nigeria Data Protection Regulation Investigation and Enforcement Team. Dr. Bakare has a PhD degree and a dual Masters of Advanced IT and Business Management from reputable universities in the United States and the United Kingdom, in addition to several related professional certifications, and is a member of the American National Security of Leadership and Success. Our second speaker is our colleague, Bassam Touma, the Business Development Manager for Africa, whom will be introducing Shelt methodology for implementing NDPR. Finally, we will try to make the session as interactive as possible. Please feel free to drop your question in the Q&A box or raise your hand. We will offer you the possibility of speaking. We will be running a poll toward the end of the webinar. We appreciate your input as well. We will also follow up by an email with a copy of the presentation and the webinar recording. We hope you find the webinar relevant and informative. Dr. Bakare, welcome. The floor is yours.
Thank you very much. Good afternoon to everyone that is present for this webinar. It's a honor and privilege for me to be invited to this auspicious event, that focuses on the Nigerian Data Protection Regulation. I trust that everyone is keeping safe, during this COVID-19 pandemic, and I pray that nobody here falls victim. Just like it was mentioned in my introduction, my name is Ayodele Bakare, and I work with the National Information Technology Development Agency. However, I am not representing the agency by participating in this webinar. Rather, I am here to share information about the NDPR based on my personal knowledge and experience with the regulation. So you may not quote NIDA in any aspect of my submission today. You can only quote me, Ayo Bakare. So now that we have that out of the way, we can now delve into the crux of the matter. That is talking about the NDPR principles, compliance requirements, and implementation and enforcement framework. I will try as much as possible to be brief because I know that I may have just about 15-20 minutes to give this brief. So the NDPR, just like any other global data protection regulation, It's a Nigerian government statute or regulation that seeks to safeguard data and privacy rights of its citizens and other entities within its jurisdiction. The regulation was issued in January 2019 under the leadership of Dr. Isa Ali Pantami, who was the DG of NIDA then, but now the Minister of Communications and Digital Economy. The NDPR is intended at safeguarding data and privacy rights of entities, from insecurity, exploitation, and privacy, abuse. It is also intended to create awareness for citizens and relevant entities on their data and privacy rights and how they can, report and get redress for any perceived violations. Additionally, the regulation aims at preserving individuals' rights, to confidentiality, integrity, and availability. So what I'm trying to say is that at the center of this, of this regulation lies individuals' personally identifiable information, which must be protected from abuse, exploitation, and other information insecurity. Examples of personally identifiable information include names, phone numbers, email address, house address, bank verification number, and car number plates, and any other information that can be used to identify an individual. So the question is this: why is it important that this information be protected? It is important for this information to be protected, because individuals or organizations with bad intentions can identify the owners of this information, harm them, or exploit them. For example, there was this case of a gang in Lagos where, that was arrested, I think about 2 weeks ago for identity theft. Okay, they specialize in stealing phones and then use a combination of phone number and other personal information, located in the phone to move money from the phone owner's bank account, okay, to their own bank account. So in this example, it will be impossible for those malicious individuals to perpetrate this evil without laying their hands on the individual's personally identifiable information. I'm just using this to underscore the importance, of your personally identifiable information. So the NDPR will apply to data belonging to Nigerians, both at home and abroad, who are referred to as data subjects. It will also apply to all individuals and organizations in Nigeria, handling data belonging to Nigerians. And also, this category are referred to as data controllers. And finally, it will apply to all foreign entities and that handle, data belonging to Nigerians, and this category also is referred to as data controllers. So now that I've briefly introduced the NDPR, I will quickly run through the principles and compliance requirements, very briefly. Meanwhile, majority of this will apply to data controllers and processors. Remember that, the kings and queens, that the NDPR protects, are the data subjects. However, data subjects are also expected to ensure that, data controllers abide by these principles, before giving their information out to them. Data subjects are also advised to report violations, of these principles and requirements to NIDA. So I will paraphrase and summarize these principles for the sake of time and comprehension. You may later, acquaint yourself with the regulation for more information. The regulation can be found on www.nidda.gov.ng, because I can assure you that even 2 hours, may not be enough to distill, the whole regulation. So this is just a brief overview. So going forward, data controllers, must only collect data for legitimate use, subject to the consent of the data subject. For example, if you are in charge of, say, for example, a bank, telecommunication company, satellite video company, government organizations, that collect data from Nigerians, then you must seek the permission of the owner of the data before collection and use it legally. Okay, so one of the ways of seeking permission of the data subject is by putting just a simple, and conspicuous, privacy policy on the medium of data collection and request that data subject consent to the policy statement before submitting their personal as data. So media for placement of policy statements may include your websites and other physical data collection points. Data controllers should never transfer data subjects, data to third parties without the consent of the data subject. Meaning that you cannot share customers' data with any other entity without seeking the permission of your customers. For example, some data controllers use affiliates or contractors to process the data of their customers. Some even use Google Analytics to assess the performance of their website, and portals, which may contain, customers' personal data. In this situation, the NDPR mandates that the customers must not only be aware of the use of their information by third parties, but must give consent. So data controllers must keep customers' data for only the period needed and should be deleted once this period expires. So you are not allowed to keep your customers, data forever, as some data controllers, might as a belief. No, you are not expected to do that. At a particular time, in fact, you are supposed to give the period for holding your customers as in data. And when that period expires, you are expected to explicitly delete the information. So going forward, data controllers must deploy all the necessary information security measures to protect, their customers' personal data, meaning that you are expected to implement both technical and administrative information security measures, to protect your customers' data from threats, such as malware attack, hacker attack, other environmental disasters, such as flooding and fire, So for example, technical information security measures may involve the installation of firewalls, may involve the installation of things like intrusion prevention and detection systems, and also anti-malware. Additionally, you may be expected to install things like disaster recovery system for your information system. Or you can just simply, outsource this, to a third-party company that is certified in information security. So we're not saying that as a data controller that you must have all this deployed. You can outsource this, to a company such as Shelt. I'm sure Shelt can provide, some of these measures, without unnecessarily bothering the data controller. So administrative information security measures may also involve providing the necessary data protection and information security training, for all staff that will handle customer data. Also, data controllers will be solely responsible for data subjects' data and be held responsible by NDPR, meaning that NDPR will not tolerate any excuse that a third party or data processor is responsible for the violation of the NDPR. As far as NDPR is concerned, all data controller will be held responsible for the protection of their clients or customers' data. That is talking about the data subject. So requirement for compliance with the NDPR includes familiarity with the NDPR. Obviously, organizations collecting data and data subjects should ensure that they read and understand the NDPR. If you do not understand the NDPR, there is no point, in going forward in order to comply with other requirements. Okay, so data controllers are required to comply with the guiding principles of the NDPR. Just like I stated earlier, data controllers using third-party data processors should ensure that they have a formal contractual agreement with these data processors and ensure that the data processors understand the requirements of the NDPR. It's really very important. Okay, if I'm talking of data processor, I'm talking of people or entities who will process the data on behalf of the data controller. But in some cases, you have the data controller also processing, such as in data. Or in case you are having a third-party data processor, ensure that the data processor understands the requirements and have a contractual agreement. Otherwise, liability will not be visited upon the data processor. Rather, liability will be visited upon by NDPR on the data controller. So I think it's really very imperative that our data controllers, understand this. Then data controllers, are required to train and designate a data protection officer. Okay, if you recall, I talked about DPCO. DPCO means Data Protection Compliance Organization. There is also a need for a data protection officer. Okay, so a data controller are required to train and designate a data protection officer that will help the data controller comply, with the NDPR. Also, the position of a DPO can be outsourced to a company certified, maybe in data protection and information security. However, data controllers cannot outsource, and I repeat, you cannot outsource the position of a DPO to a data protection compliance organization. I think this should be very instructional. You cannot do that. Why? Because a DPCO is a private organization with requisite qualifications in data protection and information security licensed by NDPR to train, audit, and provide other consultancy services to data controllers to help them, comply with the NDPR. So you cannot outsource the position of a DPO to the same entity that is expected to audit you. Otherwise, there would definitely, be a conflict of interest. So you are advised against that. Moving forward, if a data controller processes more than 1,000 personal data in 6 months, then a soft copy of the summary audits shall be submitted, to NDPR. However, data controllers are expected to submit their summary audits reports, to NDPR annually, not later than the 15th of March of the following year. That is, if the data controller processes more than 2,000 data subjects within that same year. The content of the summary report is available, if you check under part 4, section 4.15 of the NDPR, you see the content of the audit summary. That is, we are conducting the audit. There are specific requirements you are supposed to ensure that, you comply with. So you can see a list, I can't mention that here, but you can find a list of that in under part 4, section 4.15 of the NDPR. So now that I have also talked, about the NDPR compliance requirements and implementation, I will briefly talk about the NDPR enforcement framework. So in enforcing the NDPR, 2 major entities will be involved, namely NDPR and the DPCOs. And like I mentioned earlier, the DPCOs will ensure that organization comply by providing training and auditing services to them. DPCOs are also obliged to report any observed violations of the regulations, to NDPR. And NDPR, on the other hand, will utilize the administrative redress panel to address any violations of the NDPR. The panel, consists of the NDPR committee, the NDPR investigation and enforcement team, of course, which I, belong, and the Nigerian police force. So once a violation is reported or observed, the administrative redress panel investigates and provides a report of the investigation within 28 working days. Sorry, hope I'm within time, or I've passed my time.
No, you're still within time, but I just wanted to mention to all the attendees that Dr. Bakare is giving an overview from a government perspective, and then we can tap into the different, because people are asking where are the different discussion slides. So we will share with you.
Okay, good. So I think I will just quickly, I will just quickly round off now, please. Okay. Yes, because I know that we have limited time. So to conclude this, I will say this: if an organization or individual is found guilty of violating the NDPR, then the entity will be required to pay 10 million naira, or 2% of its annual gross revenue for the preceding year, or whichever is greater, if it handles more than 10,000 data subjects. But if the entity handles less than 10,000 data subjects, then the entity will be required to pay a sum of 2 billion naira, or 1% of its annual gross revenue, whichever is as in greater. So, based on the press, on time, I think I'll have to stop here for now. However, I'm still available for questions, comments that may arise.
Definitely.
Thank you very much for listening. Hope I didn't take much of your time.
Definitely, the topic is very, condensed, and it has a lot of materials. And as you said, it, Dr. Bakare, you can spend hours, and we can spend more, and especially that as a subject matter expert, so as yourself, you can guide, companies and institutions and people as well, to comply and, to the NDPR. Usually, from our perspective, from Shelt's perspective, we are a consulting company in cybersecurity and focused, on different regulatory frameworks for data protection and data security. Let's say we're working on GDPR, but we also, since its introduction in the market, we're actively pursuing on the NDPR, requirements and for the organization. And we really are happy that Nigeria has taken this, lead in Africa. And, from NITA perspective, definitely, but also embracing it in the Nigerian community, because data, everybody is saying that the data is the new oil, as they say. So data is something very, very precious. And data privacy also belongs to person, as Dr. Bakare mentioned it. There is a right for the subjects also for privacy of their data. So it's important, and we see it from a security perspective, since we're a cybersecurity focused company, that when criminals are attacking you, it's not only because they want to, let's say, as an organization, to have a financial, gain directly, but also are attacking companies for their data, because data holds value. And second, as Dr. Bakare mentioned it, there is a pillar for the rights of how data should be stored, how it should be kept, how it should be processed, what is the reason, and mostly data shouldn't be processed without the proper consent of the data subject. And to give this consent, the data subject needs to understand his rights, needs to fundamentally understand the right of its subject. Definitely, there are guiding principles enforced by the NDPR, and as you've seen it, I think Dr. Bakare went as an overall on these principles. But there are sections very well documented in the NDPR from Shelt's understanding regarding different sections, whether it's regarding transparency of and clarity of privacy policy, and Dr. Bakare really started with that, and this is very crucial that people understand that every organization, and whenever they're submitting their data, that there is a clear privacy policy and unambiguous, which is not very technical and addressed to the class, let's say, per se of these data subjects. Also, there are principles revolving provision of proper motives, data integrity, and storage limitation. Dr. Bakare mentioned that you cannot store forever information. It should be stored with a reasonably needed time to process such data. Of course, the most important part of these principles is the consent. The consent should be given by the data subject owner in a non-ambiguous way to the data processor to process this data. So there are different also lawfulness of processing and how it is structured. For example, sometimes you need to process data to inform the public of specific interests. Let's say new news that are affecting specific data subject, that you need to proliferate this information. So there is a public interest in that, but of course there is also the legal and the security from a national perspective also that entails processing these data. And as Dr. Bakare mentioned, if you don't confine, as per the NDPR, you will be fined. And the question to you, Doctor, also, may I ask you this question? how did the Nigerian community receive such regulation, and how does the enterprise embrace so far from your understanding? Do you see, I mean, how do you see the impact of the NDPR on the overall Nigerian community?
Okay, thank you very much, Mr. Abassam. Without trying to represent NIDA, just like I mentioned earlier, I think the reception of the NDPR was really fulfilling, and encouraging. In fact, the NDPR is one of NIDA's, that is National Information Technology Development Agency's star regulation, in terms of its popularity, in terms of the success and the interest that it has generated among public and private sectors, and also the international community. And I can tell you that, this was underscored by the turnout of the stakeholders from different sectors, during the World Data Privacy Day that was hosted by NIDA, and the Ministry of Communications and Digital Economy. Sometimes I think it should be, January 28th this year.
And I mean, you mentioned that there is an audit. Is it mandatory for all? Because when you gave the overview, there should be a specific size of how much of users or data subjects a company is processing data to be able to comply, or it's regardless of the number of data subjects for a company to comply or a data processor to comply to the NDPR.
Sorry, I didn't get that very well.
So is there any size of the, depending on the size of the data processor that he should comply, or any data processor needs to comply?
Okay, like I mentioned earlier, as stated clearly, by the regulation, there are two categories of data controller that is expected to comply. The first category are data controllers, okay, that process under 1,000 data subjects. For those category of data controllers, they are expected to submit within 6 months a copy of their data protection audit to NIDA. There's another category, okay, which handles data subjects of up to 2,000. For that category, they are expected to conduct a yearly audit in collaboration with the DPCOs. So those ones are expected to do that and have their audit report or the summary of the audit report submitted by 15th of March of the succeeding year. But if you are doing under that, the regulation does not, does not compel you, to submit any sort of, data audit to NIDA. But of course, you are advised, even if you are collecting less than that, you are advised to do regular data protection compliance audits. Thank you.
Thank you. Thank you so much for your answer, Dr. Bakare.
I have a question here, Bassam, Dr. Bakare. Well,
yes,
Bassam mentioned that data controllers, it is required that data controllers share or tell the data subjects what is being done with their data. So to which extent Nigerian data controllers are communicating such policies or such processing with the data subjects? Do data subjects really aware what is being done with their data?
Okay, well, thank you for that question. That is a very good question. Okay, I can tell you that was what even necessitated the issuance of the NDPR in the first place. Because NIDA and other stakeholders, within the industry realizes that data controller were not communicating such information. Okay, it might be done either intentionally or out of omission. And that is why the NDPR is out to ensure that, this problem, that was observed, can be corrected.
Thank you.
Thank you. So I think we have a lot of Q&As being asked. Dr. Bakare, you will have a lot to to answer, because I've seen that there is more than 15 questions so far asked on the Q&A. So I think we'll have some answers at the end of this presentation. But moving forward, there are definitely legal grounds and data subject rights clearly defined in the NDPR. What is the legal ground for processing data? Definitely, we mentioned that it is consent-based, but sometimes it's for legal obligation, there is vital interests, there is lawful authority and public interest, and there is a legitimate interest, but also there is data subject rights that Dr. Bakare mentioned that are clearly also well defined in the NDPR per se. So our view, this is from our perspective, we see that the NDPR approach, in order to facilitate it, we see that there should be two phases. The phase one is the maturity assessment to what is the situation as is from NDPR perspective. So we gather as much as information as possible, and we start analyzing them and create this gap assessment of non-conformities and the prioritization of actions. Because at some point, data processors and data owners will have some relevant controls in place, but there might be weak in other areas. And in specific areas, the gain or the impact will be great. And this is why we believe that there should be a risk-based approach to assessing the maturity level of an organization from an NDPR perspective. The second is to create the action plan to become NDPR compliant. So at first, there should be a gap assessment. Second, there should be an NDPR compliant action plan that an organization. How we see it from our perspective is that first, we need to establish the maturity level of an organization based on the different topics and principles mentioned in the NDPR. From 0 to 5, accordingly, 0 meaning there is non-existing either policies or process or procedures, to 5 being the most optimized and having advanced capability. So when you have this scaling in perspective, you will be able to consider the different governance, metrics, processes needed, and establish what we call a strategic program to move forward and to be able to comply with the NDPR requirement. Definitely, we also see it from a risk perspective, having the impact of from risks on non-conforming to certain areas or having less maturity in certain area will entail some risk. Some of them might be low, some of them might be extremely high, where it can have a business disruption, brand impacts, financial penalties, especially that the NDPR has a financial fine and penalty very clearly defined. And then at the end of the day, we will reach a roadmap where we can establish quick wins, medium-term and long-term action plans to enable the organization becoming NDPR compliant. We can represent all the different topic based on a spider chart, based on the maturity scoring within each area of interest, and therefore having a complete visibility from as-is perspective to where what is the company target state, let's say. And then eventually create this kind of a maturity scoring based on the different topics and the different actions within the NDPR. So we will have more of a representation of all the elements and the risk statement. And clearly, once we have all this grasp, in a very informative and detailed and very structured manner, we are able to offer the roadmap for an action plan evolving what needs to be done from different departments within the organization, especially focusing on what Dr. Bakare mentioned, the DPO function that will have a lot of load, but also other areas from information security, from IT. Dr. Bakare mentioned that you need to have, let's say, specific controls from an information security perspective to protect the organization from breaches, from data being exfiltrated, etc., and any compliancy from legal perspective. Suhair, if you're talking, you're muted.
Yes. Okay. So as I can see that Shelt has a really very comprehensive methodology in conducting the gap assessment and the implementation in compliance with the requirements. And this could be a very lengthy process. My question is to Dr. Bakare. What recommendation would you give in order to accelerate this process and make it as smooth and as fast as possible? Because we know when we talk about audit and compliance, everybody gets stressed, everybody gets afraid. So what advice you could give to organizations in order to make the procedure, I mean, a pleasant journey and as fast as possible and as agile and light as possible?
Okay, thank you very much for that question. And I want to start with this. I don't really think that it is a Herculean task, for data controllers or organizations, that handle data to comply with the NDPR, okay? Because the regulation is there and it's well spelled out. The only challenge that I see here, based on my experience, is a lack of awareness, and the requisite training for compliance. And that is why NDPR is focusing more on awareness creation, in collaboration with the DPCOs, sectoral regulators, and other relevant stakeholders. Additionally, controllers may need to invest more on information security infrastructure, to ensure compliance. I can tell you that if the gap, of awareness is taken away, most of what is required may not be too Herculean. For example, it doesn't take much, to put a privacy statement, on your website. It takes nothing, but if you're not aware of it, then definitely you cannot do that. So that is the only major issue that I see here. And like I mentioned, NDPR is, has put in strategies to ensure that every person or every entity rather concerned, be it from the private sector or from the public sector, is actually aware of the NDPR and what's are the requirements for compliance. Thank you.
So I understand that there is a high requirement for training in order to close the awareness gap. So any formal training programs in place? Is there any specific certification requirement, for example, for the data privacy officer? Any track you could recommend or suggest?
Okay, well, there is no specific training requirement, by NDPR, but what I can tell you is that to ensure that an organization and DPOs are up to standards, in terms of the requirement by the NDPR, then definitely they will need to be versed in the areas of data protection and also in the areas of information security. So once this trainings are provided to the DPOs and the concerned organizations, I'm sure that they shouldn't really have a problem complying with the NDPR.
Thank you.
Yeah, you're welcome.
I think we have some interesting questions. I don't know if Suhair, we can ask these questions.
Yeah, of course. Well, from the audience,
more than 20 questions being raised.
I have 20 questions, and we can proceed with them one by one. So we have a question from Mr. Abu Bakr Zubairu. How can banks delete personal information of customers without jeopardizing the integrity of transaction logs on customer accounts? Dr. Bakare?
Okay, yes, that is a very interesting question. Okay, this particular rule that has to do with data retention and deletion may not apply to all data controllers. For example, just like you rightly said, banks, okay, may need to keep the data of their customers, for a very long time, for posterity. But what is important here is that such data controller that fall into such category should ensure that they communicate this to the data subject. Remember, the data subject here is king and queen. So anything that is, to be implemented by such organization or data controller needs to be communicated. Okay, not only communicated, it must be consented to by the data subject. I think those are the two things that are really very important here.
Okay, from NDPR viewpoint, how long can CCTV footage be retained if not required for investigation? This is a case question.
I'm very sorry. Can you repeat that? A phone call came in now and interrupted me. So please repeat that.
Yes. So from NDPR viewpoint, how long can CCTV footage be retained if not required for an investigation?
Yes, I think it depends on the data controller, okay, that is storing such information, okay? And also may be dependent on their internal policy. For example, some organizations might have as part of their policy, maybe 2 months, data retention. Some might have a policy on 1 year data retention. Some may have a policy, okay, that states that the retention, period should be 5 years. But what is important here is to ensure that this is communicated to the data subject and the data subject consents, okay, to that policy before submitting their information. I think this is the key point here. Key point is communication and also consent. Okay? Thank you.
Okay. We have a question from Mr. Stephen Abiona. For banking industry, there are a lot of bankers here, where customer data collection and update is on ongoing basis. What data records will qualify to be filed in the annual compliance report to the regulator? What is the period for the entire data update on both new and existing customers?
Okay, yes, that's a very good question. And I think my answer to this, okay, lies in the negotiation between the data controller and the DPCO. Remember, NIDA will not be directly involved in the audit. Rather, the DPCO will be involved with the data controller on the audit, okay? But I can tell you that, in agreement, okay, with the, as a DPCO, certain data, okay, may definitely, as a warrant, shorter periods, okay, for storage, while others, might warrant longer periods for storage. But what is important here is to ensure that you negotiate this with your DPCO. And I'm sure that the DPCO, on getting to your site, will definitely brief you, okay, on the requirements, or the types of data required for the audit. But if I can tell you offhand, data that should consist, your audit should definitely be personally identifiable information. For example, the name of your customers, the phone number of your customers, okay, the address of your customers, the email of your customers, things like that. Those are the things that are expected. But I'm not giving that as an exhaustive list. No, there may be others. But I'm just giving you typical examples of what constitutes a personally identifiable information that should be part of your summary audit reports. Okay, but like I mentioned earlier, the DPCO should, will be in that position to give you an exhaustive list. Thank you.
Thank you. We have a very interesting question. Yes, Basa, sorry. Yeah. From Mr. Adipati Oyrende. So he's saying, thank you for shedding more light, Dr. Dr. Bakare, sorry, on the NDPR. Can you explain the DPCO audit function as opposed to the DPO's function and how the conflict of interest could occur?
Okay, to start with this, in the area of conflict of interest, there is no way you as a DPCO will be given the role of a DPO, okay, because you are expected to perform an audit. So in essence, if a DPCO becomes a DPO, it means you'll be auditing yourself and you can never rely on the report, of such audits. So that is where the conflict of interest comes in. And like I mentioned earlier, there is there's a distinction between the functions of a DPCO and a DPO. A DPCO is a private organization, maybe an organization qualified in the area of data protection or information security, licensed by NDPR to perform training, to conduct audits, and also, perform other consultancy in order to ensure that data controllers comply with the Nigerian data protection regulation. That is on the one side. On the other side, you have the DPO. The DPO, there's a position that is expected, okay, to be designated by the data controller to help the data controller comply with the NDPR, okay? The DPO may be expected to be like a liaison between the data controller and also the DPCO, okay?
So we can say that it is like the internal audit and the external audit functions of the organization.
Yes. So, I'm still even trying to land here. So a DPO can be designated as an internal staff by the data controller, meaning that the data controller can actually identify a staff, train that staff, in the areas of data protection and also in the areas of information security to serve as the DPO. So also, a data controller might say, hey, I don't think I have that kind of expertise, within. I want to outsource this to a third-party company. That is allowed. But what is not allowed is for such position to be outsourced to a DPCO, okay? Because a conflict of interest will definitely arise. It means that, the audit reports, to be generated by such DPCO will lack integrity. Thank you.
Okay, so before proceeding with other questions, I just need to kick the poll for the webinar. I appreciate your opinion. Bassam, you may continue with the next question, please.
Yeah, sure. I mean, there is an interesting question here regarding data being stored on the cloud and cloud platforms. So basically mentioning that the data is not locally in Nigeria, but rather than on the cloud. So how do you see, Dr. Bakare, the implication of that on the from an NDPR perspective?
Okay, are you talking about the implication of moving data overseas?
To the cloud, yes. On the cloud, overseas, yes, of course. If it is
okay. Well, I will try as much as possible to answer this, within the confines of the provision of the NDPR. Okay, and it's clearly stated there that in as much as possible, that data controllers are advised to store data locally. There may be some situations where data may need to be stored in a foreign jurisdiction. And if that situation occurs, it is expected, okay, that permission is sought from the Honorable Attorney General of the Federation and NDPR before such is done. And if approval is given, NDPR and the Attorney General of the Federation, will confirm and ensure that that foreign jurisdiction provides the same level of data protection as the one offered by the NDPR. It's as simple as that.
Thank you. Thank you. There is a question I would like also to address, but you talked about the cybersecurity, and which is a component, of course, required by the NDPR to enforce the security controls, especially that sometimes critical data is being exfiltrated by ransomware and malware, or subject to these kind of cybersecurity threats. So do you have anything to impose, or let's say the organization need to have some protective measures in place to validate it as proof that to comply to NDPR? So that's a question. So how to protect critical data from ransomware and malware threats? And I think it's related to the NDPR, because it's clearly said, NDPR mentioned that that section as well, right?
Okay, yes, you are very right, and thank you for that question. Obviously you cannot divorce cybersecurity from NDPR. Okay, cybersecurity is an integral part of the compliance, with the NDPR. That is talking about implementation of administrative controls, or the implementation of technical controls, or as a measure. So it is expected, as you will explicitly see in the NDPR, data controllers are advised to ensure that all of these controls are in place, to ensure that the data of their, of their data subjects, are well protected. Additionally, to address this concern, NIDA also has a full-fledged cybersecurity department that has done a lot in terms of providing the requisite cybersecurity awareness to the public as a sector. NIDA has also partnered with other sectoral regulations, to train organizations within their sectors on cybersecurity. And I can tell you that NIDA has also licensed, about 70 DPCOs. Right now we have about 70 to provide training for data controllers, either within the public or private sector, on cybersecurity, and other requirements, for compliance with the NDPR. So we are very aware of this, and we've put in the right strategy and the right mechanism, to ensure that, there is no gap, in ensuring that, our controllers comply with the NDPR. Thank you.
Thanks a lot for your answers. And there is, so many questions. I think
but no time.
cover them all in one session. The question keep coming.
All the answers are in the regulation. If you read the regulation, you see all the answers there.
But there is one. I don't know if you can still have one or few questions, but there is one question raised that regarding the responsibility of data privacy. Does it fall with a DPO function as a separate, or can be done by the CISO from a cybersecurity perspective, or can we have a shared, responsibility or shared function, as a CISO will have two hats? Let's say the CISO within the DPO within.
Yeah, obviously it's a composite responsibility, which means that, it should be shared. Okay. NDPR is one aspect, okay? And you require enforcement of cybersecurity, information security to achieve compliance. So in essence, what I'm trying to say is that for you to comply and to ensure that, you implement the right cybersecurity measures or information security measures, definitely, you require the input of a CISO, okay? I don't know whether I'm making sense with this. You require the input of a CISO.
Yeah.
But regardless, you are expected to have a DPO. Okay? A DPO will just be like a liaison, like a proxy, between the data controller and the DPCO, and with as a NIDA. So what happens? What happens in between the CISO, the DPO, and other information security personnel, should be regarded as an internal operation within the organization or the data controller. What we expect is that do whatever is required to ensure that you comply with the regulation.
Perfect. Thank you. Thank you.
I
don't know if
have a question, because there were many questions coming about the implications of COVID on the personal information. On one side, were it a motive to introduce some leniency measure in terms of the deadlines and the reporting needs? And also, did you get many claims about, do you have information about many claims coming in terms of breaches triggered by the COVID?
Sorry, I didn't get that very well. It's not really clear.
Yes, I mean, we're having questions about the impact of COVID on the personal data. On one side, in terms of reporting and the requirements for compliance, were there any leniency measures due to COVID? I mean, exceptional period. This is on one side. On the other side, were there many breaches reported due to the cyber attackers' COVID behavior?
Okay, I can see that your question are of two folds. Okay, so I'll try and answer the first one. The first one has to do with providing leniency, okay, in the deadline for submission of audits, right? Yes. Okay, good. Okay, to answer that, I will go back. Back memory lane. When this regulation was issued in January 2019, a grace period of 6 months was actually given by NDPR to data controllers, to ensure that they make themselves, as versed as possible with this regulation. So, meaning that for the first 6 months, no enforcement, was carried out by NDPR. Going forward, beyond that 6 months, NDPR, still extended that grace, I think till about, January or February this year. So I believe that if NDPR, has done that, I don't see any reason, for any data controller to have any excuse in terms of compliance or in terms of ensuring that, their audits is generated and submitted, through the DPCOs. Then on the second aspect of your question, which has to do with whether we have been receiving notifications or reports, especially in this COVID-19 period. Well, I can only speak for myself on this. As far as I'm concerned, I have not actually received any report on this. But that is not to say that, because, just like I explained earlier, the committee for the NDPR, we have different subcommittees, and different subcommittees handles different aspects of the NDPR. So it's possible, that some of them may have received. But personally, because I am part of, the NDPR investigation and enforcement team, so some of this I expected to come to me. But personally speaking, I have not received any. Okay. However, NDPR had been proactive throughout the period of the pandemic to scan through every web applications within the country. And we have issued warnings, okay, to organizations that are running web applications that are not compliant, with the NDPR. So I think we've done this as a proactive measure, just to ensure that, people or malicious individuals do not take advantage of the general migration of activities and transactions, businesses, to the cyberspace, to start, defrauding people, or causing all sorts of information, insecurity. We are very aware of this, and we also acknowledge the fact that, there have been an increase in, cyber insecurity, let me put it that way. But in my own opinion and experience, most of the ones that have been experienced are due to successfully implemented social engineering, okay, and not necessarily complacency on the part of the data controllers in protecting the data of their data subjects. I hope I'm making sense with this.
Yes, pretty much.
Okay, okay.
One final question, if you allow me, Bassambi, but because there are really many, but we don't want to take much time of Dr. Bakare.
This question by writing, because you know, for the sake of time and
exactly, yes.
you know,
So some of these questions can be sent, you know, and we can always respond via email.
yes.
Okay. So as a concluding remark, Dr. Bakare, because when I asked you about the training, you mentioned that there are two challenges. One of them is the awareness gap. The other one is the security posture of the organization, that they should have cybersecurity measures in the organization. We as Shelt, as a security, cybersecurity service providers, what recommendation would you give to organizations in order to improve their security posture that would help them, in addition to awareness and the requirements to become cybersecurity, to become NDPR compliant?
Okay, well, first off, I do not think that any single information security best practice alone will suffice in ensuring compliance, you know, with the NDPR. Rather, a composite of technical and administrative measures or best practice will be most effective at ensuring compliance. So there is no shortcut to it, okay? And the implementation of this best practices, you know, which focus, you know, and the implementation of this best practice starts with the generation of an organizational information security policy. You cannot run away from it. Even organizations, you know, that are not data controllers, okay, that implement some sort of information system or information technology are advised to ensure that they have an information security. So for a data controller, I think that is a first step. It shouldn't take you too much effort, time, and you know, finances, you know, to ensure that you do that. You must have a solid and actionable information security policy. And this information security policy must focus on people, processes, data, data transmission, software applications, hardware infrastructure, and relevant government regulations, you know, or as in statutes. So once you have that policy, everything that needs to be done will be embedded in the policy, and it makes it easier, you know, to implement. So once again, no single strategy will help any data controller, you know, comply with the NDPR. Rather, you need to, you know, juxtapose all strategies, you know, talking about administrative strategies, talking about you know, technical strategies. You have to put all this together and make sure that you know, your organization implements them to ensure that you know, you comply with the NDPR. Thank you very much.
Thank you very much, Dr. Bakare. It's really a pleasure and an honor. Bassam, you can conclude. Thank you very much.
No, I mean, I just wanted to first and foremost thank Dr. Bakare for his insights and valuable information shared. And I hope that all the attendees and participants have benefited from that. At the end of the day, Dr. Bakare mentioned about awareness, and we are happy to provide these kinds of services and awareness sessions, and making the use of, you know, these endeavors that the Nigeria is leading with. At the end of the day, it's for the benefit of the community, definitely benefit of the organization, and also to benefit for the benefit of the citizens of Nigeria and the residents of Nigeria. So at the end of the day, you know, all these improvements will have impact on the business, positively on the business as well. So it's not like only for auditing or processing perspective, but they will have impact. And we believe that we've seen it since we're active in Nigeria a lot, that nowadays data is being, you know, very much the focus of an economy with all this digital transformation happening, the cloud providers coming into the country as well. So there is a paradigm shift in how I mean, economy is created through digital channels. And we believe that these kind of regulations are quite important. And you know, whatever we can advise, and we're happy to be part of this. So we thank you, Dr. Bakare. We'd like to thank every one of our participants for your time, and we hope to see you in future events. Thanks a lot, Dr.
Thank you, and have a good evening.
Thank you, everyone, for attending. Thank you.
Thank you.
Thank you.